The Supreme Court struck down Section 4 of the Voting Rights Act today. It's a Voting Rights Act of 1965. It's a landmark civil rights law, and the decision has far-reaching implications for voting rights and election laws in this country. The case, Shelby County, Alabama versus Holder, was a challenge to Congress's 2006 reauthorization of the landmark civil rights law that designates which parts of the country must clear any changes to their voting laws and voting procedures with the federal government. The court ruled 5-4 that methodology Congress used to designate which states needed pre-clearance was outdated and therefore unconstitutional.
The decision is huge. And although the court only struck down Section 4B of the Voting Rights Act, which is the coverage formula, in effect, it really does invalidate Section 5, because without a coverage formula, there are no states that need pre-clearance. And so really Section 4B and Section 5 work together. So the opinion, in essence, says that Congress can provide a remedy by updating the coverage formula, but given the gridlock in Congress, it's very unlikely that that will happen.
Chief Justice Roberts, in his majority opinion today, writing for himself and the other four Republican-appointed conservatives on the court, wrote, while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions. So, Fernita, what does he mean by current conditions? What was Section 4B, the coverage formula, before today based on?
Section 4B was based on those states that had the worst voting rights records as of 1965, and then it was updated again in 1970. And so when Congress renewed the Voting Rights Act in 2006, it did not update that coverage formula. So those states that were initially covered in 1965 and 1970 remain covered. A few months ago, I wrote a blog post where I talked about the fact that it's likely that Section 4B would go and the court would uphold Section 5, because that way it looks like the court isn't really undoing the second Reconstruction, even if in practice it does have that effect.